Hello everyone and welcome. In this session we're exploring the third element of negligence, causation. Remember, to succeed in a negligence claim, a claimant must prove three things. Firstly, that the defendant owed them a duty of care. Secondly, that the defendant breached that duty. And thirdly, that the breach caused the claimant's damage. This final stage, causation, asks, did the breach actually cause the harm? And is the damage legally attributable to the defendant? So the claimant has to prove that the defendant's breach caused their loss. There must be a direct link between the defendant's act and the harm suffered. Sometimes this is called the chain of causation. Causation itself is considered in two parts. Firstly, causation in fact, the factual link. Did the damage occur because of the breach? We use a legal test called the but-for test for this, which we'll discuss in just a second. Secondly, causation in law, whether the damage is sufficiently proximate or not too remote to be recoverable. In what follows, we'll discuss both of these two legs of causation. The starting point is the but-for test from the case of Cork and Kirby McLean. The courts ask, would the damage have occurred but for the defendant's breach? I'll just repeat that. Would the damage have occurred but for the defendant's breach? If the answer is no, the harm would not have happened without the breach, then causation is established. But if the harm would have occurred anyway, then the breach did not cause the damage. Then obviously something else did. If the harm would have occurred anyway, then the breach did not cause the damage. And this was illustrated very well in the following case. In Barnet and Chelsea and Kensington Hospital Management, a man drank contaminated tea and was taken ill. Upon attending hospital, he was turned away from its casualty department, and he later died from arsenic poisoning, arsenic being a very toxic poison. The court held that, without doubt, the casualty officer should have seen and examined the deceased, and that his failure to do so was negligence. So the court took the first two elements of negligence to be proven: duty of care. The hospital did owe the man a duty of care, and they did breach their duty. They did fall below the standard that we would have expected them to adhere to. However, the claimant's widow's negligence claim fell apart on the basis of causation. It was proven that the man would have died even if the doctor at casualty had treated him. Therefore, he would not have died but for the hospital's failure to treat him. He would have died anyway. And therefore, the hospital was held not liable because their action did not cause the harm that was suffered. The but-for test therefore works very well for straightforward cases. But real life often involves multiple causes, complications, or intervening events. So we are going to look at those problematic areas. Difficulties arise where there are multiple causes or an intervening act, often referred to by lawyers as novus auctus interveniens. Multiple causes could be furthermore split into either consecutive causes or simultaneous multiple causes. If a new independent event breaks the causal chain, the defendant will not be liable for the harm that follows. For example, if another person or an unforeseeable event interrupts the sequence, then it can absolve the original defendant. But in other cases, like overlapping causes, the courts have developed special approaches. Where there are multiple simultaneous causes, the courts look for a material contribution to the harm. So let's first look at cases where there are two possible causes. In Bonington Castings Limited and Wardlaw, the claimant inhaled dust from two sources. One of these sources was innocent and one source was there because of negligence. The court held that if the defendant's breach materially contributed to the disease, then liability was established, even if it was not the only cause. Then, afterwards, in McGee and National Coal Board, the court said that it was enough that the defendant's breach materially increased the risk of the harm occurring. So you can see how this widened it from materially contributed to the damage itself to materially contributed to the risk of the damage occurring. But this is only if we have two possible causes. So then we're looking at just tilting the balance of probabilities, which is, of course, the standard of proof that we have in civil cases. Where we've got more than two possible causes, the statistics don't favor, 50-50. So let's say that there are three possible causes. If they're all three equally likely to have caused or to have contributed, then we're looking at a third, which falls below more than 50%. So when we've got this, the claimant has to prove which one actually caused the damage. So, for example, in the leading case of Wiltshire versus Essex Area Health Authority, the court said that where there are several different possible causes, the claimant has to prove which one actually, on a balance of probabilities, caused the damage. So the courts are more lenient when there's single cause operating in different degrees, but stricter when there are independent alternative causes. Sometimes damages arise in sequence rather than at the same time. The general rule is to apply the but-for test to each cause. For example, in Performance Cars and Abraham, a car already damaged in one accident was struck again. The second driver wasn't held liable for damage that already existed. However, please do take notice that the courts make an exception in the so-called mesothelioma cases. Mesothelioma being a kind of lung cancer that is caused by asbestos fibers. In Fairchild and Glenhaven Funeral Services, workers that were exposed to asbestos by multiple employers could not prove which one of the incidents during which employment actually caused their illness. They could have inhaled the relevant microscopic asbestos fiber during any of those employments. The House of Lords held that if each employer materially increased the risk, they could all be held liable, and this is on a joint and several basis. However, later in Barker and Corris, the House of Lords limited this to proportional liability, so each defendant only liable for his own proportion, which of course was favourable towards the defendants, but not so favourable towards the claimant, who couldn't get their entire damage, for instance, because some of the employers had gone out of business. However, Parliament then intervened, and Section 3 of the Compensation Act 2006 restored joint and several liability, meaning that one defendant could be held liable for the entire damage, even if there were other defendants who also were involved. So from the perspective of the claimant will get their entire damage. The defendant stands the chance of having to pay more than their share to cover the entire damage. That defendant will then have the right to sue the other possible defendants for a contribution. But if they don't exist, for example, then it would be the loss of the defendant, not the loss of the claimant. Please do revise the difference between joint liability, several liability, and joint and several liability. Let's go back. So today, in mesothelioma cases, claimants do not need to pinpoint the exact cause. It's enough to show increased risk, and if there are multiple possible defendants, one can be held liable on a joint and several basis for the entire damage. Another issue is the so-called loss of a chance cases, especially in medical negligence. This is where a person loses out on a chance of recovery due to the negligence of the defendant. The courts are generally reluctant to impose liability unless the chance of avoiding the harm was above 50%. Once again, we get to that balance of probabilities, which is the standard of proof in civil cases. You have to just convince the court that it's more likely rather than less likely, meaning more than 50% likelihood that what you are saying is the case. In Gregg versus Scott, a lump was misdiagnosed, reducing the patient's survival chances from 42% to 25%. The claimant's claim in negligence failed because the initial chance was below 50% anyway. Similarly, in Hodson and East Berkshire Health Authority, a 25% of avoiding deformity proven by the claimant was too low, so the claimant couldn't prove that the negligence more probably than not, caused the outcome. So this illustrates that in English law, possibility is not enough. It must be probability on the balance of evidence. Tilting, more than 50%. That then brings us to the end of factual causation and the but-for test and how that works. There's a second leg to causation, however. So even if factual causation is proven, the court must still decide whether the damage is too remote. This is called legal causation. It's a question of law, often guided by policy to avoid limitless liability. Earlier, following the precedent of the case of regarding Polamus, liability was based on the direct consequences regardless of foreseeability, meaning that if you caused something, if something was the direct consequence of your breach, you were held liable, whether you could foresee it or not. That rule was replaced by the precedent set in the Wagon Mound number 1, which established the reasonable foreseeability test for negligence claims. So the harm has to be of a type that a reasonable person could have anticipated, even if the extent or the manner of its occurrence wasn't predictable. To summarize, therefore, causation links the breach of duty on the part of the defendant to the damage suffered by the claimant. Factual causation asks, would the harm have occurred but for the defendant's act? Legal causation asks, was the damage reasonably foreseeable or too remote? The courts consider special issues such as intervening acts, multiple causes, mesothelioma exposure, and loss of a chance. Together, these principles form the core of what you need to know about the third and final element in a negligence claim to be proven by the claimant, namely that the breach of duty of care caused the damage suffered. Thank you for watching, and I'll see you in the next one.